Okay, well, I think I'll start introducing. So Margaret has an interesting background. So Margaret's a vice dean at Robert Gordon University. Is it a vice dean? Sorry, you're the associate dean, economic, social, and cultural. Forgive me.
It's a
Um,
strange title.
well, maybe going to explain it. I'm part of the law school, and it does some really interesting work on dispute resolution. I noticed some interesting stuff on the NHS and how it deals with particularly medical difficulties and so on. Done a lot of work on various areas, and obviously employment is a big area of expertise for you, Margaret. Now mediating with Edinburgh Sheriff Court Mediation Service, and the topic, I have to say, is a subject of great fascination to me. And before I hand over to you, Margaret, I just want to ask if anyone would put their hand up if they understand the rules and the financial consequences of uncapped expenses, what people are actually likely to pay in a case of over £3,000. Anyone feel they know that?
And if they do know it, could they please do this talk instead of me?
So, and I think that was kind of what I was banking on, because certainly, I mean, I've looked at it quite a lot, and it's still baffling. So, really delighted to get some input on this, which I think is an unhelpful oversight in simple procedure rules and should probably be put right, but it's not going to be anytime soon. So, in the meantime, Margaret, if I could hand over to you.
Thank you. And I'd just like to say to Patrick that I was absolutely fascinated by his talk, and I look forward to reading his article. I've just written so many notes about it. Sandy very kindly asked me to talk about simple procedure claim expenses, and I thought, that sounds interesting. It won't take me too long to work this out. Oh my goodness. So I was aware there were problems because some of the cases I've been mediating, I think the parties talk about expenses and they don't understand, and they've also talked to the sheriff clerk or whoever, and they still don't understand what's going on. So I went away and I looked in it in more detail, and I also went to talk to some of my friends who are litigators to see what was happening on the ground. I didn't go as far as talking to the sheriffs, which I probably should have. Let's see if I can share this. Okay, can you see that? Yeah, just shout if you can, and feel free to interrupt me at any point. I'm going to talk about the rules. I'm going to talk about some of the case law, but mostly I would quite like to focus on the practical aspects. Or how do we deal with this uncertainty in practice? Because it's certainly not particularly obvious, the attitude that the courts are taking. So we all know what simple claim is. Simple claims can be used for payment of some money where the value of the claim is £5,000 or less, and basically delivery or recovery of possession of movable property where there's an alternative claim for payment of a sum of £5,000 or less. And the same with order for specific implement with an alternative crave of £5,000 or less. And I swiped that from the Sheriff Court's website because the actual statutory provision is much more complicated. But I know ingrained in all of your minds when you're mediating is this limit of £5,000 or less. When the party has raised a simple procedure claim, it's supposed to be flexible, it's supposed to be easy to understand. You're not supposed to need a lawyer, although you can feel free to bring a lawyer. And the problem, or I don't know if it's a problem, but legal aid is not available. And so therefore the costs are not usually too high, but increasingly parties have been bringing legal representation into the simple procedure cases, and we see a lot of that coming through the mediation, where solicitors want to come and represent their clients. When the client has, or when the party has brought a simple procedure case, they do have to pay the fees, which at the moment are £20 for lodging a claim form, which is £300 or less, the value of the claim, and other claims £112 for lodging the claim form. In the event that they want to appeal a final decision of the sheriff, then they have to pay £65 for marking an appeal. As well as that, if they require service by sheriff officers, they have to pay an additional fee of £15 plus the cost of the sheriff officer's fees, which can actually be quite considerable. And that has to be borne in mind when trying to help them reach a settlement and a claim. I think it's all too easy to forget to ask what expenses were incurred and what are they going to do about the expenses. So the Courts Reform Scotland Act 2014, which you're all probably aware of, set up the modern court system in Scotland, and Section 81, subsection 1, states that the Scottish ministers may make an order restricting expenses, but the order does not apply in certain circumstances, which are set out in sections 81.4 and 81.5 of the 2014 Act. Where I can, I've linked to the legislation, and I'll not use Westlaw in case you don't have access to Westlaw. So you just have to be careful that any links lead you to legislation which is up to date. So the order that was made is the Simple Procedure Limits on Award of Expenses Order 2016. And when I talk about the order, that's what I'm talking about. When I talk about the Act, I'm talking about the 2014 Act. And I'll come back to the order. I'll come back to the Act in a minute. So the order sets out the restrictions in simple procedure cases. Generally, expenses will follow success. So if a party wins the case, then an order for expenses will be made by the sheriff. The restriction on the expenses awardable in a simple procedure claim depend on the value of the claim. So up to and including £300. Oh, wait a minute, I can't see my own slides. Where have they gone? Okay. That should say £20 in there, I think. Greater than 300, but not more than 1,500 is £150. Greater than 1,500, but not more than 3,000. Expenses are capped at no more than 10% of the value of the claim. Greater than £3,000, there is no cap. And remember that simple claims can go up to £5,000. So it's quite possible that if the parties settle for more than £3,000 in a mediation, then there would be no cap on the expenses awarded, and they would normally follow the undefended scale. Oh, sorry, I can't hear that. Did somebody ask me a question? No, okay. If the case law sort of highlights some of the problems that that are being encountered in practice. So, for example, what happens if the sum sued for is greater than the actual sum awarded? Which scale is used for expenses? Are the restricted expenses in place? So in Graham against Farrell, the claimant argued that the cap on expenses shouldn't apply, as the sum sued for in the claim form was in excess of £3,000. The sum actually awarded by the court was less than £3,000. And of course, the unsuccessful defender was suggesting that that shouldn't apply. So the court held, and I don't think this was a surprise to anybody, that the sum awarded in the decree is what will determine whether a cap applies, and not the sum originally sought in the claim form, because obviously otherwise you are going to have the problem that people will put in excessive claims just to get over the £3,000. And actually, I think I do see that happening in claims. The parties do that, or the pursuer does that, so that they can then threaten to ask for expenses in excess of the cap. Okay. Okay. Another question which has arisen is, do these limits include VAT and outlays? Well, we've spoken about the outlays of bringing a claim. In addition, actually, although it's not mentioned in the case law, there is the possibility of claiming interest at 8% on the sum sued for. Unfortunately, the case law is inconclusive on this point. We have Gowns against Miller, where it's concluded that they wouldn't be payable in addition to the capped amount, and the capped amount includes VAT and outlays. And we have Andrew Martin against Southern Rock Insurance Company Limited, where the sheriff held that the court outlay for raising a simple procedure claim and VAT were payable in addition to the capped expenses. So it really isn't clear, and it seems to vary from sheriff court to sheriff court. Oh, I lost that one. Right. The other problem is that according to the 2014 Act, according to the 2014 Act, there are certain situations where the order does not apply. In other words, capped expenses do not apply in these circumstances. The first one is that in relation to an appeal to the Sheriff Appeal Court from any decision in a simple procedure case, the cap doesn't apply. Where the sheriff thinks that there's a difficult question of law or a question of fact or exceptional complexity, then the cap doesn't apply. So there's always a danger that in those circumstances that the cap will not exist in an order of expenses. The one that's causing most problems is that the order does not apply where the defender has not stated a defence, or having stated a defence has not proceeded with it, or having stated and proceeded with a defence has not acted in good faith as to its merits. And it's the one in the middle there that seems to have attracted the most attention. Firstly, what happens when the case goes to mediation after defences have been lodged, or even in the event that they've not stated a defence at all, but the case law is mainly concerning defences have been lodged, then there is some kind of extrajudicial settlement, either by an accepted tender before proof, or a mediation, or the parties have just negotiated a settlement and the proof gets cancelled. They've reached an agreement. They haven't been particularly focused on expenses, and then there's an argument about whether or not the order capping the expenses applies. So some of the case law on this, Graham against Farrell, most of these are sheriff's decisions. I'll let you know if it's not a sheriff's decision. Graham against Farrell, in Edinburgh Sheriff Court, the court granted an order for payment of £3,000 plus expenses on the undefended scale, i.e. they decided that the cap did not apply because the defender had lodged a tender after the unsuccessful mediation, but the case settled before proof. And in that, I'm not going to go through all the cases, you'll be really glad to know, but in that case, the sheriff followed Tallow against Clark, which was also an Edinburgh Sheriff Court decision, where expenses were awarded on the summary cause scale. Some of these cases are obviously older than the simple claim procedure, but the legislation in force then, which capped expenses due for small claims, had identical wording. And so that case law seems to have been adopted. So in Tallow against Clark, the expense was awarded on the summary cause scale. The appeal, there was an appeal by stated case. And what happened was that there was a small claim defences were lodged before the matter settled extrajudicially. So instead of awarding expenses on the small claim scale, summary cause expenses were awarded because it was held that the defences had been lodged but not proceeded with. And that was upheld in the stated case. And the other two cases on that list basically follow the same sort of reasoning. Sorry, it's a bit hot in here. I'm in a room with no window. It's a nightmare. So far so good, really simple. The only problem is that at virtually the same time as some of these cases are ongoing, another approach is being taken in other sheriffdoms and by other sheriff principals. And the problem is particularly arising in these cases where somebody has lodged a defence. They haven't denied liability, but they have disputed quantum. So it's a partial defence, if you see what I mean. The problem then arises is that a defence which has been put forward and then not proceeded with? Is it a defence at all? Is there any way round the situation? And you can see that actually a different approach is developed in these cases. So in my case note, lost my case note. In Semple against Black, what basically happened was that the case was only disputed in terms of the quantum, and then it settled just before the court case. And there were several arguments which went on appeal in the stated case, but the one that concerns us is the argument about the cap on expenses. And the argument there, find it, basically what happened is a tender for £750 was lodged, but a tender was lodged and accepted, and the wording, and I think I wanted to get the wording right here because the expenses in the tender were expenses as taxed of process. And I think that's particularly relevant for mediators when we're drafting settlement agreements, is to be very careful about the wording, because there was a huge dispute about, does that mean it has to be taxed on summary cause scale, because that's the only one where there's provision for taxation, or not. But as far as the cap was concerned, the sheriff held that the cap didn't apply, awarded expenses on the summary scale rather than the small claim scale, as the defence had been lodged but not proceeded with. And the interesting part was the second part of the decision, where it was held that the sheriff was also entitled to exercise general discretion as to the level of expenses awarded. So in other words, yes, a defence has been lodged, it's not been proceeded with, so the cap's gone. But on the other hand, the sheriff has this all-encompassing discretion about expenses, and therefore can adjust the level of expenses awarded. And that was quite an interesting decision, and it was followed, or it's referred to and approved in Davis against Skyfire Insurance, where it was held that a cap on expenses didn't apply where the defender stated a defence in quantum and didn't proceed with it. the cap didn't apply, they would have to pay undefended expenses. However, the principles of simple procedure to the question of discretion and expenses would allow the sheriff to apply the cap by a different means, which is a bit sneaky, I think. Don't know what you think, but I think it's a bit sneaky. And a similar decision reached in McKinley against Aviva, where the defence and quantum only settled before the second evidential hearing. And the same principle was applied. So that all sounds very complicated, but what does it actually mean in practice? I think it means that depending on which sheriffdom you're in, there might be a slightly different approach to expenses. I wonder, as mediators, do we have to worry about this? My inclination is that yes, we do. Other situations that the expenses, right? Other situations where the order capping expenses doesn't apply, where any party has behaved in a manner which is manifestly unreasonable in relation to the case. I don't think any of us here will ever have come across any unreasonably behaved parties, so that shouldn't be an issue. The wording used to just be in an unreasonable manner, but it's changed. It's not clear if that's going to make any difference. If expenses are not capped, then the expenses will depend on whether the successful party was legally represented, the amount and nature of the work done, and the length of any hearings. And it's really quite difficult to predict because of the discretion of the sheriff. I couldn't find very much on whether or not expenses will be granted in full, the full scale expenses, if a party is not legally represented. So I went a digging, and according to the Citizens Advice Bureau, that won't be awarded. So then I texted all my friends to see what they came back with, and they came back with instances of it actually happening where an unrepresented party is just given the scale fee and expenses when they're successful, and others said, no, that wouldn't happen. So I've not really reached a conclusion on that one. So I think the questions for the mediators, and to answer Pauline's question, yes, probably do need breakout rooms for this. What does it matter for us? Well, it really does matter, because should you include the topic of expenses in the negotiation? How would you do that? How detailed would the discussion be? And I've had several times the parties asking for an explanation of the rules regarding expenses during the course of the mediation. But what would your response be? Okay. Does anybody want to ask me any questions before we put you into breakout rooms to consider these questions?
Could I just ask a quick clarifying something that is really sort of worrying me about all the things that I've been saying to parties all of these years. So these expenses, can parties, so parties, a successful party is able to claim following a mediation that's settled. Is that, am I right in thinking that?
In theory. So a lot
In
of these
theory,
cases
if they
are
choose to
about,
do so.
well, in theory, because a lot of these, this is part of what I want you to discuss actually.
Hmm.
How would you stop that happening? So if you kind of hold that thought and discuss it in your breakout group, I think that's one of the first things we need to discuss.
Hmm.
Just on that point, our incidental application to request dismissal of action expressly states that the parties need to sign that up, and assuming the settlement agreement is fully implemented, the settlement agreement will contain language which says that the sum being paid, and assuming it's a sum of money, will be without the award of costs by or to either party to the settlement agreement.
Yeah.
And
I think that would normally be the case, Sandy, and you're jumping ahead to the solution. But I don't think we can say that it's always the case.
Mhm.
So maybe Pauline could put you into breakout rooms for 10 minutes to discuss these points. You think 10 minutes will be enough? Okay, would somebody like to report back from group 1?
Well, I think I'm supposed to, Margaret, because you told me I had to, but I did suggest you should report back to yourself. But
I told you you should volunteer, did I?
Yes. I think the consensus here was that the best thing to do might be to raise the question of expenses at the very start of the process, so that it wasn't something that risked derailing a process by being into or coming as a new point at the end of a mediation. So saying one of the things that you will need to think about is the question of legal expenses in the course of this discussion, and it's best that you have that in mind as you go through this. We also thought that, and I think our experience was that in no case had there been a final agreement where it had been suggested that expenses would be fixed by a sheriff. It was all packaged up in the main agreement and not left as an open thread. The other thing that we thought that would be very useful would be to have an information sheet which could be provided to the parties in advance of the mediation, so that it gave the best chance for people to be on equal footing in terms of their understanding. And we also thought it would be quite a good thing for that cheat sheet to be provided to the mediators too, so that we, on a one-page laminated sheet, had something close to our hearts that would give us the answer every time.
Thank you. Group
Sorry
2?
to interject there, but there is one that we used to get given at Edinburgh Sheriff Court. I've still got one in my drawer.
Okay. That'd be interesting. Maybe you could share it with Pauline.
Adrian, that would be helpful if you could share that.
Yeah.
I don't know when that date's from.
I was just about to say the same. I wasn't aware of that.
Yeah.
Yeah. And I think
Can I just follow up on what David was saying? I can understand why getting this show early in the mediation might be very helpful. In practice, what we see, and this is quite consistent, is that the agreed settlement sum is in full and final settlement of whatever, without expenses being due to or by either party, and that's within a settlement agreement template. I've not seen, I can't recall having seen any settlement agreement which requires to or gets into legal expenses because the settlement sum agreed is in full and final settlement. So as a matter of practice, there is a bit of a risk by highlighting early doors in mediation. You know, what do you think about expenses? We frankly, as mediators, don't know what that ultimately translates to. The parties are going to find that difficult to understand. In many ways, if people agree to offer, to pay, or to accept on the basis that whatever's gone before is yesterday's matter, and that what they're prepared to pay or accept is cognizance that they're giving up any other claim they had, whether for expenses or otherwise, that in a sense makes it a bit more straightforward to achieve resolution. And so there's a kind of tension between, do you broach this early doors as an issue where the answer to that is unclear, or do you say as a mediator, we can't advise on this, but by the way, here's a sheet of paper which tells you as much as you can expect to know, but the bottom line on that is it's still very uncertain. You know, it's difficult.
It is very difficult. Does anybody want to feedback from group 2?
The other point that I made was that once we know the settlement agreement has been fully implemented, we get an incidental application signed up by the parties, which records that the mediation service has, the dispute has been resolved extrajudicially, and the mediation service has been asked to submit an application to have the claim dismissed in the Sheriff Court. so that we know when final implementation of the settlement agreement has been achieved, and we control it being put in front of a sheriff to get it closed off in the sheriff court.
It's interesting. I mean, I think you really wouldn't be doing the best job as a mediator if expenses weren't tied up. But I think the difficulty is, when do you deal with that? When do you deal with that? Do you deal with it at the beginning as part of the sum claimed, or do you risk the fact that they might come up with it? You might almost be settled when somebody says, "Oh, wait a minute, I have to pay the sheriff officers. And by the way, what about the expenses of my solicitor?" Okay, who was group two? Sorry, Sandy, on you go.
No.
I've
No, I
got
was
the
going to
delay.
say, I would encourage
Just
the parties.
conscious, sorry, we're up against it for time,
Yeah.
so I just want to note we're after.
Okay. Maybe we don't have time to go around all the groups. That's fine. I'm happy to leave it there. I think we've had an interesting discussion.
Yeah, I mean, it does seem a shame because I think we had a fascinating discussion, and it's made me think about a number of things. I think we do have an expenses sheet at the mediation clinic, so a bit more than happy to share that. I think we had a look at it quite recently. But the case law, Margaret, I just want to say one thing on the two cases, the more recent ones, Davis and Skyfire, McKinley and Aviva, they were both negotiations not done by mediation. They were rather carelessly, I think, arrived at by the lawyers, with expenses not being dealt with.
I don't think any of these cases were mediators. They were all tenders.
Yeah,
as a result of judicial mediation. And I think that the lawyers can learn from the mediators.
Yeah.
You know.
And Sandy's wording, I think we need to look at our wording, whether it says no expenses due to or by either party. That's a new thing. Look, thank you, Margaret, and you, Patrick, as well. We're packing a lot into these sessions. I'm conscious of the time, and I think people have to go. But can we just show our appreciation for both our speakers this afternoon? And yeah, we'll share your PowerPoints. Is that okay?
Yeah, sure. And if anybody wants to email me any questions, I would be, especially any experience of expenses causing a problem, I'd be really interested. Thanks. Actually, I have to run as well now.
Yeah. Okay. Thanks, everybody.
Thanks so much, everybody.
Thanks, Margaret. Very good. Thank you very much.
Appreciate it.
Thanks, everybody.
Thank you.